Hello.
Hello, Professor Michael Tharakan. Uh,
Can you hear me?
yes, we can hear you.
Okay.
We are waiting for Professor Karthikeyan Nair also to
Uh-huh.
join. And Professor Anupama Roy is already here.
Hello.
Uh, Welcome, Professor
Thank you
Anupama
so
Roy.
much. Thank you for inviting me.
Yeah. Uh, you know, they might have told you that I'm very unsure of this technology.
We are all learning.
Hello,
Hello.
Professor Michael Tharakan. The director is not able to connect to his microphone due to some technical problems. So I think we can begin. Friends, KCHR is very happy to welcome you all to the fifth webinar of the KCHR webinar series, Contemporary History of Citizenship in India, Law and Belonging by Professor Anupama Roy, Center for Political Studies, JNU. So this talk was originally planned as a public lecture around March, April, and once the COVID situation started, um, we thought of moving this further and into and now as a webinar, which I think will be our only viable option for the few more months to come. We are very glad that Professor Anupama Roy kindly agreed to give us this webinar, and this was originally planned, as you know, in March when the issue of citizenship was much widely discussed over the country. And currently also we are in a situation where the question of citizenship has come up prominently in the last few days. I welcome Professor Anupama Roy to this gathering.
Thank you so much. Thank you for inviting me.
And welcome you all. I request all of you to kindly keep your microphones on mute, and also any queries to Professor Roy may be typed in the chat box, which will be read after. Professor Michael Kennedy, sir, could you kindly take over the proceedings?
Uh, Thank you very much. Um, First of all, let me officially welcome Professor Anupama Roy. It's very kind of you to have spared your time to present this seminar for the KCHR. Um, and I'm also grateful to all of you for having come to attend this talk. And I'm hoping that we will have a interesting discussion afterwards. I do not want to say anything about the topic as such, except that, of course, this is something which I'm sure that most of you must be um, concerned about, in the sense that this is the question of citizenship and its official legal recognition, and on what grounds it is being recognized, is a major question that is very seriously discussed and very intensely discussed, and also erupted into various kinds of debates and disagreements all over the country. And I'm sure that this is a kind of a topic which requires more solid, um, systematic, academic analysis, because this is so vital to the modern life of being a part of a nation state or a country. And I'm sure that this the kind of issues um, would finally would have to be uh, looked at from different perspectives, not from one perspective or the other or the other. And I'm sure that Professor Anupama Roy, who has got a brilliant record uh, of academic work. In fact, I was just glancing through her sort of resume, and I have to say that very rarely do we come across such a person with so much of concrete knowledge and concrete experiences in working on issues of various kinds. I mean, they're all related to a very vital portion of our understanding of the issues that we are going to discuss. As you all know, she's professor at the Jawaharlal Nehru University, the leading um, university in India, and we are happy to have you with us and also take part in this kind of discussion. And Anupama Roy. Thank you. Hello.
Hello. Professor Roy, there is some, I think it's from your end. It could be a ceiling fan, possibly.
Sorry?
There is some disturbance in the audio from your end. I think it could be a ceiling fan.
Okay, possible. I'll just switch it off. Give me a minute. Yeah. Yeah, I switched it off. Is it better now?
Yes, it's better. It's better.
Okay. All right. Yeah, shall I begin now? Or?
Yes, ma'am.
Okay.
Yes.
All right. Okay, thank you. Thank you so much. Thank you, Professor Tharakan and KCHR for having invited me. As Rebecca said, this was something that was scheduled to take place in March. We decided in March that I'd come in April, but no, by the end of March, we knew that this was not going to happen. But the webinar has made it possible. So thanks to technology, we are able to join and have a discussion on something that has been animating the country for almost 2 years or more now. I have been given about 45 minutes to speak. So I will, for the span of 45 minutes, I will try and raise some issues that we could probably open up for a detailed discussion later in the hour that we have for discussion. This is the presentation is primarily about the citizenship law. Before I start talking about the citizenship law and the way in which, as social scientists, one would study a law, a specific kind of law, why or what do I mean by citizenship, or what is contestation around the meaning of citizenship. And again, very briefly, if one was to go by the conventional understanding of citizenship that is attributed to the British sociologist T.H. Marshall, who said that citizenship is full and equal membership in the political community. No, there is something about the fullness of this membership in something called the political community that becomes important. No, so no, how do we understand this fullness and the attribute of equality is something that we need to talk about. You know, in some quarters, citizenship is understood as a kind of collective governance, a mode through which a people would collectively and autonomously govern themselves. In some quarters, it is understood as a legal status to which entitlements, privileges, and duties accrue. But it's also associated with the state formative practices. And state formative practices would mean that citizenship would be a primary mode, particularly in modern state forms, through which states continuously reproduce themselves, produce both what could be called the structural effect of the state and also through law, the power effect of the state. So that could be one understanding. Weber would perhaps think of it in terms of closures, where you include some and exclude some, create boundary conditions. There would be others who would perhaps look at it in terms of the constitution of a community of persons who would relate to the state as a political community, which would be the source of their primary membership. Others would perhaps see citizenship as a task that state performs to ensure that the state is the primary universe of membership and would competitively edge out all other communities of membership. So there are all these different understandings of citizenship. And when we look at the law of citizenship, perhaps we may try and see what are these various understandings of citizenship that come across when we look at the law. Again, and since I'm talking primarily, I'm assuming, to a community of historians, and historians are particularly careful about methodology. What is the kind of methodology that one would use when one studies a law? No, any law, not necessarily a citizenship law. So anthropologists would tell us that when you study a law, there is a possibility of studying law itself as an anthropological subject. You think of law itself as having a life. Law does not remain stagnant. It's dynamic. It changes. It could change through amendments that are made in the structure of law itself, or law could travel from one site to another, as it did in colonial contexts, and assume different kinds of meanings. Law could change through interpretative practices of courts or through implementations at particular sites of implementation. So law would have different kinds of lives, and law could be subjected then to an anthropological inquiry as a subject of an inquiry. But law can also create subjects. Law has a function of creating anthropological function of creating subjects of particular kinds. So if one would look at a law such as the SC/ST Prevention of Atrocities Act, law through that act creates a subject, SC/ST, and a class of offense, which is atrocities. The citizenship law performs this function as well, of creating subjects of particular kind. And while creating this subject, it also marks out certain subjects which would be out of the ambit of citizenship, or it can specifically mention it in the law itself. And that category has been mentioned since 1986 in the Citizenship Law of India. That is the category of the illegal migrant. And much of the changes in the citizenship law over the years have taken place around this category of illegal migrant. So, while we hold on to this idea that illegal migrant is a category that is integral, that has been integral to the enunciation of law over a period of time, 1986 right up to 2016 and 2019, there have been different articulations of this illegal migrant, and I will in a short while discuss how that different kinds of articulations have been. But in terms of the looking at law as having a life, how does one pin together or weave together in a narrative of a particular kind the different kinds of changes that have taken place over a period of years? So when one looks at the text of the law itself, and the text of the law comes like a bare act, so this is a text of says bare act, and bare act is quite symbolic in the sense that the text would remain bare until we add life to it, and procedurally lives are added or inserted into an act through rules. We all know that the Citizenship Amendment Act 2019, the rules for the act have not been framed so far, and the government has asked for a 3-month time to frame those rules. Rules would be one way in which life would be given to an act in terms of how that law can be implemented. But life can be given to law also in terms of the way in which law impacts and has ramifications on people. So what is the relationship between law and people? So that would be another way of looking at law in terms of having a life. There would also be a third way of looking at law as having a life, which would be to see how law has changed over a period of time. And when we look at the bare act, there are signposts, unmistakable signposts along the life of the law, which tell us that this is the point at which the law has changed. And when the CA 2016, CAB 2016 was discussed before it became 2019, there was this contention that it's the same law. Nothing has changed. It's the same law. Something has been tweaked to make space for a particular category of people who could become citizens. But by and large, the law remains the same. So that was a contention that was being made. I would argue that each amendment in the citizenship law, and not only CAA 2019, each amendment 1986 onwards has put in place a different law altogether. So I would therefore say that the regime of citizenship that we see in this country has changed over a period of time, 1986 to 2003 to 2019. And the regime of citizenship law is not only in terms of how law has been structured, but in terms of the discursive framing, the legitimation that, the legitimation practices that say that this law, what is the necessity of this law and why this law is indispensable. That is something that is different each time. And at this moment, the contemporary moment of citizenship, we see that all these legitimation practices have somehow come to coalesce and make this moment a particularly significant moment in the life of citizenship in the country. Now, if one was to look at the 1986 moment of the citizenship law, this was the moment, as all of us know, that the amendment in the citizenship law was made in response to the movement in Assam around the foreigners' question and its resolution through the Assam Accord. And the Assam Accord had different provisions. One of those provisions was to ensure or put in place a legal framework through which the foreigners' question can be resolved. And the Assam Accord put in different signposts against a chronological signpost through which citizenship of foreigners in Assam can be decided, and illegal migrants can be identified and expelled. So the Assam Accord led to one of the first important changes in the Citizenship Act. And for the first time, the category of illegal migrant figured in the citizenship law, but in the form of an exception for Assam. So these were exceptional provisions which were expected to reflect maybe the something that in the citizenship literature is called differentiated citizenship, so that the universe of the citizenship is enriched by making space for differential aspirations. So the differential aspirations of the people of Assam were accommodated through the Assam exception, the articles, section 6A of the Citizenship Act, which, however, put in place a graded system of citizenship in Assam so that one had a universal, we citizens of Assam whose citizenship was undisputed. There were those who, identified under the Foreigners Act, who came into Assam between 1966 and 1971, whose names would be scratched out of the electoral rolls, which would mean that they would have deferred citizenship, and after 10 years of the date of their identification, they could be enrolled back onto the electoral rolls and they could become full citizens of the country. Now, around the same time, then there were all these people, the residual citizens, identified under then the IMDT Act, who would be illegal migrants and expelled from the country. So that was the graded citizenship framework. But around this time, there was also a change that was made in citizenship by birth provisions, which said that anybody born in India could be an Indian citizen only if one of the parents was also an Indian citizen. So we see that there is, at this point in time, an important change that's taking place in the citizenship law, which weaves in an Assam exception and also constrains citizenship by birth to ally it with the conditions of descent. So birth is allied with descent to make it conditional. And then we see a tendency in law where law is moving towards association with descent. So the model of citizenship, which looks at citizenship as something that is about the kind of relationships that people who form the political community have among themselves. So it's not a relationship between one individual and the other, but the kind of relationship that one would express or reflect as a specific community. So there is a tendency already in 1986. In 2003, we see this kind of getting more entrenched, where on the one hand, there is a kind of expression that, there is an entire diasporic community out there, who is nostalgic about the citizenship that they have left behind, and they look at the passports with nostalgia and affection. So, and a recognition of affective belonging through through the category of the overseas citizen of India was inserted in the Citizenship Act. So there appears to be something like a deterritorialized notion of citizenship which goes beyond nation-state belonging. So we recognize as citizens, not in terms of holding passports, but people who left India could belong to India in some ways. So there would be an effective belonging that would be in the country that they have adopted, but there would be an affective belonging to the country that has been left behind. So kind of taking, ensuring that the bonds of belonging to those who were of Indian origin can remain intact. So that seems to have been one of the purposes of the citizenship, of inserting the category of the OCI. Alongside, however, there was a change in the provisions of citizenship by birth. And for the first time, the category of illegal migrants makes its appearance in the citizenship by birth provisions. And this is important because this change in 2003 provides a kind of a hinge point for two different trajectories of citizenship to emerge. So the illegal migrant category that was inserted in the citizenship by birth provisions says that you can be a citizenship by birth only if both your parents are Indian citizens, or one of them is an Indian citizen and the other is not an illegal migrant. So the category illegal migrant becomes important here. Also, the denial of citizenship by birth to a person born in India. So whereas the provisions say all persons born in India, an important exception is put in place to say if you are born of an illegal migrant, you cannot claim to be an Indian citizen. Now, the 2006 CAB and now the CA 2019 is addressing this provision, citizenship by birth provisions, where the category of the illegal migrant ensures that no person who has a pedigree that goes to an illegal migrant can claim illegal citizenship. Can claim citizenship of the country. There was this other tendency also that emerges out of the Citizenship Amendment Act 2003, which led to the NRC in Assam. So as all of us know, the 2003 amendment put in place provisions which made it the responsibility of the central government to prepare a national register of citizens and issue national identity cards. The central government, once it decides that it has to do this, it can make it compulsory, but it's not compulsory for the central government to do it. So there is this important difference where the provisions say that the central government may, if it wishes, prepare a national register of citizens. Again, the procedures which were laid down in the rules made a different set of provisions or procedures for Assam. Whereas if an NRC was to be prepared for the rest of the country, the procedure would be for the registration authorities to undertake a house-to-house enumeration. For the people of Assam, the procedure was to apply for insertion into the citizenship register, and this was not a fresh preparation of the NRC. It would be an updation of an existing NRC which was made in 1951, and everybody who applied for the insertion of their names in the NRC would have to produce evidence through specified documents that they were related to a person whose name was on the legacy data. And the legacy data was constituted by the 1951 NRC and the electoral rolls up to 1971. So again, this peculiar category of legacy, of the tracing of your origins to a person who was there at the founding moment becomes part of the procedures of identifying citizens. So the tendency that I was talking about again earlier in 1986 becomes more entrenched and congealed in 2003, where there is an emphatic movement to identification of citizenship to descent through legacy in the case of NRC, especially in the case of Assam, and through the idea in the CAA, whereas the CAA does not take away anybody's citizenship, the idea that there is a provision where the territory of India can be seen as a home to which people can return. And this privilege of returning through exceptions or exemptions that the Citizenship Act provided to the category of illegal migrant that had been inserted in 2003 amendment, those exceptions would apply to only 6 religions from 3 countries. No, we all know what 3 countries: Pakistan, Bangladesh, and Afghanistan, and 6 religions, which are, when all of them except Muslims could claim a return to India, that could then qualify as a place of home. And so again, the tendency that there could be something called or an idea that there is perhaps a tie that can be expressed in terms of belonging through a criteria that is religion. So for the first time again, religion becomes a defining characteristic of citizenship in the country. Now, the trajectory seems to be from 1986 to 2003. There seems to be a tendency where a definitive alliance of birth with descent seems to have taken place, alongside the idea that citizenship can be conflated with the idea of a people, and that idea of a people can go back to a sentiment that was perhaps rejected in the Constituent Assembly debates. Now, while there seems to be again a kind of a linear evolution of citizenship in terms of going from birth to descent, each of these moments, as I said earlier, is a moment that is marked with conscious decision making. It's not as if the citizenship law is of its own volition changing. No, there's something that is specific to the political context within which these changes occur, and which is why one would use the framework of chronosophy that I listed in the abstract, which becomes appropriate for looking at the changes in the citizenship law. An argument that I would build from here would be, and for this I would need to go to the moment where the provisions of citizenship as they exist in the Constituent Assembly were discussed and inscribed. At that moment, that is the citizenship, the debates on the citizenship in the Constituent Assembly, the question of belonging was discussed, and perhaps one of those few places where secularism becomes, apart from the places in the Constituent Assembly where the question of religious freedom and fundamental rights is being discussed, in the provisions, the discussions on citizenship, the idea of secularism is also discussed as something that that needs to be a principle defining citizenship. And we need to keep in mind here again, and here I would want to bring in briefly some of the issues that were discussed in the joint parliamentary committee, and why those discussions make it important for us to discuss what was discussed in the CAD. Because one of the things that the JPC says while recommending the Citizenship Amendment Bill for discussion in Parliament, one of the things that two things that the JPC refers to and refers in order to make normative claims to, or normative justifications to the changes that CAB was seeking, is to refer to Ambedkar's speech in the Constituent Assembly. And the speech that they refer specifically is the speech that Ambedkar makes in the Assembly while introducing the citizenship provisions before the Assembly for the final approval. And in this speech, Ambedkar actually says quite explicitly that the drafting committee experienced a lot of difficulties in framing the citizenship provisions. And if one looks at the way in which the Constituent Assembly functions functioned or deliberated on issues that were contentious, like the citizenship issue, one of the techniques that the Constituent Assembly used was to adopt something that is called deferral. Defer. You defer something that you cannot resolve in this moment in time. And then while deferring, you make provisions for a future body, like the Indian Parliament, to make law on a subject that you could not resolve. So that it seems that in the Constituent Assembly, the technique that was, or the innovation that the Constituent Assembly was invoking was to defer a decision on citizenship, and whatever provisions of citizenship that they were going to put in place were to hold true for only the founding moment of the Republic, only for the context of partition, for here and now. So Ambedkar says that, no, don't think that this is something general that we are doing, this is something permanent that we are doing. These are only ad hoc provisions that are not unalterable. No, they not only can these provisions be changed, but no, the Parliament can make laws, and nothing that these provisions say can derogate from the Parliament the power to make laws on citizenship for future. And the Parliament can, while doing that, change the principles altogether. So, and this is something that JPC holds on to say that this is what Ambedkar says, and we are doing nothing that we are not competent to do. It's not just what the law gives us, but this is what the Constituent Assembly also decided, when they were deliberating on citizenship. But what the JPC does not take into and kind of leaves out conveniently is to say that this was not something that went uncontested. There were two major and emphatic kinds of strands, and two emphatic strands within the Constituent Assembly that were wary of, one of them was extremely wary of the Parliament having the unfettered powers to change the law on citizenship, and unfettered powers to set aside the principles that were being articulated within the Constituent Assembly. And Nehru seems to be presenting that kind of an agonistic position, where he says that we should not forget that within the Constituent Assembly, what we are deciding is not procedures. No, those are something that the a legislative body can do. No, in the Constituent Assembly, we are here to decide principles, and those principles should be sacrosanct. So there are these two positions that are emphatically there. And if one would look at the Article 11 of the Citizenship Act, which says that the Parliament has the power to change the citizenship law in whatever way it decides, the Article 11 is also subject to other provisions of the Constitution, other provisions including the fundamental right provisions, or the preamble, the directive principles of state policy. It's not been made, it's not been buttressed against all these other provisions. Within the Constituent Assembly, however, the idea that there is the kind of debates that we've seen in the in the Parliament, or in the larger public domain on what should be the primary basis of citizenship. Should it be birth, or should it be descent? Should religion have any role in identifying citizens? All those issues were discussed in the Constituent Assembly. And one of the things that comes out extremely prominently in the Constituent Assembly, that while there were differences among the members of the Constituent Assembly, even among the members of the drafting committee who drafted the citizenship provisions, and those differences were brought out within the space of the Constituent Assembly for deliberation, the deliberations themselves were not leading on to any consensus. What had been decided in the Constituent Assembly was a kind of deference to the procedures that the Constituent Assembly had already decided for itself. We would go by what the drafting committee says. The drafting committee brings in an amendment to the citizenship provisions. We would discuss those provisions, and we would defer, however, to the amendments that the drafting committee has brought before the Assembly. And why would we defer to those provisions? Because there is a larger objective of the Constitution that we've all agreed to abide by. So it's not as if a deliberative consensus was sought to be reached in the Constituent Assembly, and something other than what the drafting committee had brought before the Assembly could have possibly been passed. But there was this sentiment that the procedures we've decided the procedures, and those procedures are in conformity with the objectives of the Constitution, and therefore the drafting committee, the amendments brought by the drafting committee are the amendments that we would pass. And if one looks at the provisions of the Citizenship Act, those provisions are perfectly in alliance with a republican notion of citizenship, which includes, or which has the space to include not just people who are found living in the country at the moment of the founding of the Indian Republic, but also people who returned to India after having made the decision to go to Pakistan once the communal violence started. And then they thought that they would want to come back to India. So there was this entire category of returnees that the Constitution also made a space for, not just migrants who were fleeing violence from Pakistan, West and East Pakistan. So there was within the Constituent Assembly, there were then debates and discussions on all these categories: migrants, returnees, whether secularism, and this is something that was discussed at length by people like K.T. Shah and P.S. Deshmukh, who said that specious arguments like secularism should not stand in the way of ensuring that India is a land where Hindus and Sikhs should always should be seen as naturally people who would be citizens of this country, just like almost like a nostalgic mimicry of the kind of religious basis on which Pakistan had been founded. And there would be then people like Nehru and Gopal Swami Iyer, who would say, no, we are not doing, when we make these provisions for returnees to come back to India, we are doing nothing that is new. We are only doing things that sensible countries in the world have done. And if you want to look for examples in places that are misguided, then the Constituent Assembly members are, of course, not going to accede to that. So there was then, within the space of the Constituent Assembly, a whole lot of a debate on the categories that have resonated yet again. Now, when we look at the debates on citizenship in the Parliament, and the petitions that have been made to the Supreme Court, following the passage of the Constituent Assembly, and the kind of agitations in the streets that have erupted post the passage of the Citizenship Act. But one of the things, and I would know, it's already 3:43. How much time do I have?
Ma'am, we can speak for at least 15 minutes more.
15 more. Thank you. Thank you, Rebecca. Yeah. Okay. All right. Okay. So the one of the things that if the Constituent Assembly debates are seen as a signpost, as a historical moment that is being selectively extracted in the present context to buttress an argument for changing the law on citizenship by saying that, no, this is what Ambedkar also said. There is yet another principle or an argument that that seems to have found a lot of support among those who think that who would argue that the CAA is or the present citizenship regime is something that that does not really make a lot of difference. And I would take us back to the JPC report, the Joint Parliamentary Committee report, to kind of flag some of the arguments that the JPC made, in order to justify why the CAA in the current form was required. And this is something that was consonant with the kind of averments that were being made again within the political space, where the citizenship law was seen as something that's correcting a historical wrong. Something that happened in the past needs to be corrected, and the correction of that wrong necessitated that the premise on which citizenship was being defined needs to be therefore changed. The premise that had been agreed upon for citizenship needs to be changed, because that does not reflect the way in which people feel about belonging to the country. Now, the JPC, in its various recommendations, talked about talked about why secularism is not something that should stand in the way of making the change in law. Again, the kind of argument that K.T. Shah and P.S. Deshmukh were making in the Constituent Assembly. And in its various interactions with, and the categories the JPC used are very interesting. In the stakeholders, and the stakeholders were for the JPC, the people that the JPC members of the JPC went and met, in Gujarat, in Rajasthan, in states in the Northeast, and talked to people, and obviously they got very different kinds of depositions on what kind of changes people wanted. People from Northeast did not want the kind of changes that the refugees in Rajasthan or Gujarat wanted, and the depositions from civil society groups in Assam were very clear that the CAA would disturb the peace that had obtained in the region following in the case of Assam, following the Assam Accord. And the refugees in Rajasthan and Gujarat were, of course, concerned that their long-term visa status puts them in a liminal state which needed a closure with the protection of citizenship. Now, within the JPC, there were the interactions with experts from who knew the Constitution, made the suggestion that the category that the Citizenship Act was using, which was minority communities, the text of the Act does not say religious minorities. It uses the category minority communities and then identifies the minorities on the basis of religion. Goes on to say, these people belonging to these communities, but does not say religious minorities. It says minority communities, disease, and religious persecutions. That's how the category of religion figures. Now, what the constitutional experts, however, advised the JPC was that this provision is certainly going to be contested in the courts, and in order to buttress this provision against judicial scrutiny, what the JPC could do was to replace minority communities with persecuted minorities. So that it's persecution and the space that the minority then does not remain a religious minority. Minorities of any dispensation who are persecuted would come under the protective ambit of the CAA. Now, the JPC, however, is very it's emphatic about not losing the objective of protection on the ground of religious persecution. So the focus on religious persecution should not be lost by diluting it and making the category more capacious, making it persecuted minorities. So the buttressal of the law against the constitutional provisions is something that the JPC is concerned about. And then it says that, it takes recourse to a case in 1952, in fact, in West Bengal, Anwar Ali Sarkar versus the state of West Bengal, and the case that was decided by the Supreme Court of India, to say that, this act is perfectly fine. It does not violate the equality provisions in the Constitution. And this is something that kind of recurs and reverberated in the parliament debates as well. Now, whether or not the act goes against Article 14 of the Constitution, that is equality before the law and equal protection of the law. And they said that, we do not think that it violates the equality provisions of the Constitution, because the Supreme Court judgment in Anwar Ali Sarkar says that if the law satisfies the intelligibility and reasonableness criteria, then the act is perfect. Perfectly fine, it's constitutional. And it said that the intelligibility criteria is satisfied because we are making this law only for a specific class of people who are easily identified as a coherent class, and they're distinguishable from others. So there is a coherence about this class which makes it intelligible. And this is also an intelligible classification because it meets the objective of the Act. The objective of the Act is to provide protection to this class of people, and there is this class of people that is intelligibly there. No, it's identifiable. So there is no dissonance between the objective of the Act and the class of people for which the Act is making a provision. Now, what the JPC kind of perhaps conveniently or maybe inadvertently did not look at is that the Supreme Court judgment was actually dismissing an appeal by the West Bengal government in favor of Anwar Ali Sarkar was being tried by a special court, to say that reasonableness is not only about objectives of the Act being met by classification. It also has to satisfy the second part of the Article 14, which says equal protection of the law, which would mean that the person, a person needs to be protected also against arbitrary power of the state. So the Act also has to satisfy the criteria of not being arbitrary. So the arbitrariness criteria needs to be satisfied also thoroughly in order for an Act to be constitutional. So that is something that the Anwar Ali Sarkar judgment also said, which was not mentioned in the JPC report. Further on, something that the petitions have pointed out, petitions in the Supreme Court have pointed out. Now, there's something which there's the Nas Foundation judgment, for example, says that the objectives of the Act themselves can be placed under judicial scrutiny. It's not as if once you lay down the objectives of an Act, the objectives of the Act remain sacrosanct. They can also be put before the court for scrutiny. And in order to meet the evaluative framework of constitutionality, the objectives have to satisfy something called constitutional morality. And constitutional morality is not something which is just there as an idea. No, it's something that the Supreme Court has established as through its interpretations as something that the Supreme Court judges must use in order to displace and in order to give space to critical morality and not be guided by public morality. And this is something that the Nas Foundation judgment puts in place very clearly. And the constitutional morality is not only something that Ambedkar said in the Constituent Assembly, but it's something that's found dispersed throughout the Constitution of India in its various provisions, the fundamental rights provisions, and the other provisions as well. So there's something then that the JPC is concerned about the constitutionality and it's kind of stubborn belief that the Act is constitutional and may not be and satisfies the conditions laid down by Article 14 is something that is being contested in the Supreme Court. There's this other kind of, and I think Rebecca, I'll take 5 minutes more. There's something that happened in the kind of runs in the JPC about what exactly the change that the Citizenship Act is bringing in. What exactly is the change? While there is an entire argument running in the CA saying that the kind of citizenship that we are trying to bring is about is liberal citizenship, is nothing more, nothing less. We are worried about the rights that people would have as a consequence of their membership in the political community. So there's whole kind of consequential things that we are worried about. These would be political rights. These would be the kind of welfare that would be available to people. And those are the things that we are trying to conserve, because those are important for a coherent, integrated community. And it's something collateral, that this also involves laying down boundaries for who belongs and who does not belong. So it's not something that we are doing on purpose. No, this is something that people all over the world do. Build boundaries, and within those boundaries we ensure that equality and equal sharing happens. So what actually the JPC, the kind of citizenship that the JPC is endorsing and flagging is it's a bounded notion of citizenship, where there would be a community of citizens who would share goods among themselves, but also ensure that nothing kind of there's no porosity, there's nothing that passes goes out of these boundaries. So I would call that an idea of a national citizenship, which is based on ideas of blood ties, and it hides behind a veneer of liberal citizenship to say that no, we are worried about the rights that people can have and must completely have and be equal with those rights, and therefore we would create these boundaries. So that's one powerful argument that the JPC is making. Okay, shall I conclude here, and we can open for discussion?
Thank you, ma'am. Professor Michael Tharakan, would you like to speak to this?
Hello. Thank you very much. I think I have some questions of my own, but I will reserve it for the time being. I would request Dr. Rachel Verghese to conduct the question and answer session, so that we'll have an open discussion on this presentation. And at the end, just before summing up, I might come up with a couple of comments. Yes. Will you do that, Dr. Rachel?
Okay, thank you, sir. May I request all of you to kindly type in your questions in the chat box. I will read it out for the speaker. Ma'am, we'll wait for a couple of minutes for the questions to come.
Of course, yeah. Yeah, Professor Tharakan.
So, a suggestion has come whereby it's asked that Professor Tharakan may ask the questions first by the time the others type in their queries.
Okay. Mine is a purely kind of an inquiry. You see, because this whole question of citizenship, who is citizen, who is not, etc., comes up again and again. I was wondering whether in lawmaking, isn't precedent one of the items which is also used? How in the past we solved this problem, or if we are accepting precedent as a criteria, then in the 19th century, when most of our original diaspora of indentured laborers were taken from India to different parts of the British Empire to replace the slaves who were freed and who refused to work for their old masters but chose to work as their own in small holdings. They required laborers in plantations as well as construction projects. And the recruitment is something which historians can very well prove to have been totally secular, in the sense that people from the Sikh community, the Hindu community, and Muslim community were taken to these places. And now Indian people who are in India consider this diaspora as somebody who belongs to us. I mean, the sense that they are our, I mean, though they're not citizens as such, they don't hold any passports. They're considered to be part of our collective community living. Now, I was wondering whether this kind of an argument on the basis of precedent. I mean, I'm sure this would be very much away from the kind of arguments that you have presented, but as a pure layperson, I couldn't help asking you this question. In fact, this comes up when you study nomads and sedentary. There is a conflict in not only in the frontier areas but even in the heartland areas. For instance, I remember that in 1971 there was a very interesting paper written by Varghese and Rajeshwari on nomads in the Mysore town, and they said that people identified them as by using various terms like ascetics, beggars, people from the hills, people with no standing, and all that. You know, there is a kind of a so I mean, I'm just posing this as a question or as an inquiry.
Okay. All right. So shall I respond? And
yes, or you can wait. Or you can wait for others also to ask, and then you
can. Ma'am, would you be responding to this question first, or should I read out the next one?
Okay. I'll respond to Professor Tharakan's question.
Okay.
Yeah, and the way that I can, and the question of the power of the state is very much associated with making people who are within the purview of its jurisdiction to make them legible. So there is a way in which the state would want to read those who the state would eventually want to bring within the purview of its control or purview of its protection. So there is then always a way in which the state is wary of people who are moving. So there have been different ways in which the mobility of the people who are on move have been perceived by the state. So the criminalization of tribes, etc. Historians know it more than I do. Know how the suspicion around these people who are not stable or static in one place has been part of the way in which the state not just sees them but brings them within the purview of its administration, its administrative structures. So in recent history, not as far as 19th century, the idea that people who are moving should carry documents that would enable the state to keep a track of not just their mobility patterns, but where they are moving has taken different forms. The passport regime has been one of those forms, and the other form has been more recently the way in which technology has gone into making the mobility of some persons more possible than others. So the biometric, for example, has been one technology that the states have used to ensure that how it can sift out those who can be admitted within the state and those who who need to be kept out of the state. So the states have been wary of. States have been have pushed their machineries to ensure that people remain. And in one of the recent research that I did, and this had to do with the voting patterns of people who are on the move. People like who belong to the Bakarwal community or the Gujar community, who do not stay in one place or move periodically from the plains to the hills, and their lives, of course, does not coincide with the lives of electoral democracy. And a field research that I did in December of 2016. Now, that was immediately after the general elections of May 2016, and before the state assembly elections in Jammu and Kashmir. And this was a research that I did in the hills of Riyasi, that's in the Jammu hills, the Pir Panjal range. And in this particular district of Riyasi, which is also a site of religious pilgrimage, with the Vaishno Devi shrine being in Riyasi, the Bakarwal community living in the hills had never voted. So, and their names were not on the electoral list, and they were kind of invisible people within Indian democracy. And the Election Commission of India, and this is interesting, that the issue of election ID card to a group of people whose names had never been on the electoral roll, and ensure that these people are not given licenses to move to the hills before the election takes place, ensure that these people voted in the election. So you had in Riyasi about 83% electoral turnout from the 43% electoral turnout from the earlier election, which was because these nomadic people who are there in large numbers actually voted. And these people carried the epic with them, and we went up to the villages where they resided, in the upper regions of the Pir Panjal hills, and everybody was carrying an epic card. And in a jirga that they held, we asked them what voting meant for them, and they said that they voted this time with a lot of fervor and a jazbat, and their vote should not be seen as an endorsement of the regime, but their vote should be seen as a claim for entitlements, like they wanted school for their children, hospitals, and because the entire road was so treacherous, you could see the hills crumbling as you drove through the hills. So those were some of the things that the vote meant for them. And these were sedentary people for whom electoral democracy didn't, these were nomads for whom electoral democracy did not have the kind of meaning that it has for sedentary democracy. But the act of voting in that one election seemed to have allied those meanings to the kind of meanings that possibly all of us seem to be giving to elections, that these are claims. So there is then there are different ways in which the mobile populations are brought within the purview of the state through democratizing or democratic procedures, or through surveillance procedures like the biometric, or as far as the diaspora community is concerned, and this is interesting. One of the and speaking to historians and some of the research that I did in the National Archives, looking at the in particular the way in which in the late 1940s, 1949 right up to 1950. In this 1 year period, when there was no law on citizenship, the constitutional provisions came in 1950. We became independent in 1947, and then the election law, the citizenship law came in 1955. So there were these 2 periods of hiatus where there was no law, which, however, does not meant that people were not crossing borders, and the administration, people in charge of administration at the district level were not making decisions as to their citizenship. And one of the laws that was in the nature of a treaty agreement between Pakistan and India. Immediately after partition, when the 2 countries were not actually agreeing with each other on anything, but they agreed on one thing, which was to exchange their the women who had been abducted, the children who had been abducted and left behind, their prisoners, their lunatics. So those were some of the awkward categories that the 2 countries agreed to exchange. And one of these categories, the Abducted Persons Recovery and Restoration Act in particular, was interesting because of the way in which it was animating the Indian country in shores, or in Africa, for example. Nairobi, Indian community in Nairobi was worried that Hindu women were not being restored to India through the Abducted Persons Recovery and Restoration Act, which was the purpose of the Restoration Act. Hindu women from Pakistan needed to be recovered and restored to India, and Muslim women from India needed to be recovered and restored to Pakistan. And they were worried that Hindu women were being, smuggled out from Karachi to Nairobi. And so the diaspora community kind of got together and wrote to the Indian High Commissioner there, saying that the ports should be surveilled, and the mobility of people who could be perhaps smuggling these women should be controlled. And if that was not possible, they were offering themselves in marriage to women who would be recovered in Nairobi, the Hindu women who would be stigmatized because they had been recovered after abduction in Pakistan. So there's this the diaspora in different points in time has been relating to the country that they left behind, with different kinds of expressions of or different kinds of ties have been invoked by the diaspora. And in the 1950s, there was this one expression that I found particularly significant in the archives. The 1990s onwards has been a different kind of diaspora. When the 2003 Amendment Act was brought in, for example, the 2003 Amendment Act when it recognized the category of the OCI, it recognized as OCI people belonging to only the North American, European, and the New Zealand, Australia regions. So those were the new success stories of migrants that was recognized. A whole lot of people who went out of India as indentured labor were not recognized at the OCI until 2005. When the Indian diaspora from South Africa, for example, said, no, what is this? Is this a dollar and pound citizenship? Aren't we also people who belong to India and have the same kind of ties that the new migrants to the North American countries have had? So the ties with diaspora have also been uneven in terms of the recognition that the government was given. And one of the reasons for the 2005 amendment, in increasing the scope of the diaspora, was also because of the large amount of remittances that were being received from West Asia to states like Kerala, for example. And the diaspora in West Asia was not being recognized till 2005 as within the purview of the OCI. The OCI is under suspicion now. And if you were to look at the 2019 amendment, the 2019 amendment brings in a very significant change, saying that if any member or anybody who is an OCI, registered as an OCI, has broken a law of the country, then that person's registration may be cancelled. So if you look at the possibilities that this change can have, spreading disaffection against the Indian state, or working against the interests of the state. So if those kind of implications are drawn from this change, an OCI would not be a category that is there permanently. That could again be something that can be withdrawn by the government on the ground that a particular law has been broken, and that law was a significant law that has ramifications for something as important as sovereignty, integrity, etc. of the country. So again, the diaspora can also be suspicious. It can be within a web of suspicion, and it is not entirely also about the seeing something. Seeing the diaspora as an extension of the cultural ties that cannot be erased. So that kind of relationship is something that perhaps is also under tension.
We have a few more comments and queries.
Thank you very much. Yes.
So I will read out the next one. It's from Rahul N. May I know how the amendment in citizenship rules that included the word Hindu was contested or went uncontested?
The word Hindu was, to my knowledge, not contested. No, the word was not contested. What was contested was, and this is interesting because much of the criticism of those who are contesting the CAA is being done on the ground that those critical of the CAA are anti-Hindu, or the use of the word secular, or the fact that they are saying that this bill goes against the idea of secularism that is so integral to Indian Constitution, etc. None of if you look at the Parliament debates closely and look at the motions that were moved towards the end of the debate, if you look at the petitions that have been made in the Supreme Court, none of those petitions actually says that they want to, they're contesting the amendments because it's about Hindus or particular communities, or the contestation is because the category or the protection that is being extended to the groups that are persecuted is narrowly identified. It's not inclusive. And that's the contestation. It's not only because it leaves out Muslims, but because it leaves out a whole lot of people who are similarly persecuted. So the motions that were moved said include Muslims or make it more capacious, make it persecuted minorities. So it's the contestation is not because there is those who are being included are only Hindus or only Christians. What is being contested is the religious basis, which goes against the identifying basis or the premises of citizenship. And in case protection of citizenship is to be extended on the ground of persecution, it cannot be confined only to a few religious communities. So nowhere does it say don't give protection to Hindu refugees, no, don't give protection to Parsi refugees, or don't give protection to Christian refugees. It recognizes the problem of persecution. It does not say that no persecution happens. It says that persecution of others also happens, and not just these communities. And if you were to give protection only to these communities, then you would be discriminating. And therefore, in order to adhere to the anti-discriminatory provisions of the Constitution, and in order to adhere to what was the philosophical underpinning of citizenship in the country, it's important that these categories be modified. So as far as I know, I've read a lot of petitions and I've gone through the parliament debates. The category Hindu was not contested. So I correct me if I'm wrong. If you have some source that you can refer to, I can refer to that source and see if I'm wrong. Yeah.
The next query is from Mary Phillip. Ma'am, do you think the fact that the issues relating to citizenship could be left at the mercy of changing governments who have vested interests?
See, the Constitution says that the Parliament can make laws on citizenship. And so there is something that, if you recall the debates that you'd seen in of the Parliament on television, I saw all of them. One of the things that the Home Minister emphasized a lot, and that was legislative competence. So legislative competence was one argument that was being given. So we have the power to make laws. And it's true, the Parliament has lawmaking powers. And then there are two things that I would want to add to this. When we talk about law, if you look at the Indian Constitution, particularly the only place in the Indian Constitution that defines what a law is. Article 13 of the Constitution says, I'll just put it very crudely what the Article 13 says. Law is something that is in force in the territory of India. And Article 13 is part of the fundamental rights provisions. So law is something that is in force in the Constitution. And law shall not, the state shall not make any law which takes away or bridges the rights conferred by this part, which is the fundamental rights part, and any law made in contravention of this clause shall, to the extent of the contravention, be void. So one of the components of law in force in the territory of India, and the second component is its compatibility with the fundamental rights provisions. Now, the law in force in the territory of India is something that is seen by lawmakers or those who kind of endorse some kind of laws over others. That seems to be a paramount kind of justification. The law has been made following all procedures. This law was passed, law was introduced in Lok Sabha, law was entrusted to the JPC. JPC did its investigations, interactions, made its recommendations, gave its report, and the law was discussed in Lok Sabha. Law went to the Rajya Sabha. It was discussed and passed, endorsed by the president, and then notified. So all the procedures were followed, all the dots joined. So procedurally, the law has been made, following the procedures, made by a body that has the authority to make the law on a matter that the Constitution says it can make laws on. But there would be others who would say that the law-making function of the parliament is something that, in a democracy, the law-making function is a product of two things, all of which are integrally part of the parliament. The deliberative role that the parliament plays and the representative role that the parliament plays. And both these have to go together. The representations, the representatives of the people, when they deliberate in a space like the parliament, they are representing, because it's a democratic space, they're representing a whole range of positions and people. And in particular, they're representing, or they must necessarily represent, those who are underrepresented, which is what makes this body democratic and representative, which is why the deliberative function is important within the space of the parliament. So what I'm trying to say is, not the law-making power of the parliament, despite the fact that the parliament is authorized to make laws on certain subjects, is constrained by or enabled by other functions that it performs simultaneously, which is the representative and the deliberative functions. And the law-making function is the product of both these roles that it performs. There are scholars who say that, there is, when you test a law, when you test the constitutionality of a law, the fact that it's emerged from a competent authority is not sufficient. There are other things. For example, Tharakan would say, there are things like principles. What are the evaluative, the principles that have been followed in order to make those laws? And then these principles make the law-making function, subject to evaluation by other values like justice. So justice and fairness then become other values through which you evaluate the law-making function. There are others like the deconstructionists like Derrida who say that, even if you are authorized to make law, and there is this body that has a higher order law that authorizes you to make the law, the existence of this higher body itself is a product of an original violence. So how do you make the distinction between a just law and a violence that has emanated out of law? So there are these different kinds of things that one could talk about when one talks about the law-making function. And of course, when parliaments interpret their law-making function as a function of authority, and only authority and competence, then the laws would perhaps not be reflective of a deliberative and representative function of the parliament as well. So that's how I would respond to Mary Phillips' question.
We have a comment query next. The lecture covered the legal and philosophical aspects of conferring citizenship, such as the transformation from birth to descent to religion, becoming the criteria of defining citizenship. How about a more political reading of the CAA, such that by making immigrant Muslims as less of natural citizens, the regime is dehumanizing Muslims. Such dehumanizing and creating a national psyche about Muslims as less humans is necessary for the state to carry on its genocidal program like in Nazi Germany.
Okay, yeah. I that could be the intention of law, no, in terms of the conflation between citizenship and nation. No, so citizenship, no, as being the aspect of the collective expression of a collective identity, being conflated with an identity of a people, no, who would, no, trace it to a past which is a non-Muslim past. So there is then a conflation between citizenship and national identity, creating a community of descent, no, rather than a community tied to land and no, owing an allegiance to the constitution. No, you think of citizenship as something that is an attribute of a community that looks back at the past, which is a Hindu past. So that's part of the political ideology of Hindutva. No, there is no pretense about that, and so it's not as if that's the ruling regime, the BJP, is apologetic about it. No, they are perfectly open about it. Whether or not the Muslims or no, the large numbers of people who perhaps do not identify themselves with that ideology see Muslims as non-natural citizens, or no, people who are in a hierarchy of citizens, they are non-citizens. No, that's something that, no, that's a misrecognition that one would ascribe to no, everybody else who does not believe in that ideology. And no, before the pandemic, for example, and this is something in response to how the citizenship of or how one sees citizenship itself in a domain which is an oppositional domain, which does not believe in the kind of ideology that the kind of ideology that the CAA represents. And there was a heartening kind of expression of citizenship in a different way, which went beyond just a static legal definition of what it means to be a citizen, to say that to recall in a space which is not a designated space of protest, to come out in the streets and to say that no, we are citizens because the Constitution sees us as equal citizens. And that's the kind of equality that all of us, irrespective of whether we are Muslims, Hindus, no, we are as citizens of this country, would adhere to. And therefore then the Constitution December onwards, right up to the end of March, there were unprecedented protests across the country in which the Constitution became the most powerful symbol of protest, and one of the most popular texts and bestseller at some point, where people would read out of the Constitution. So there is then this strong strand of people who refuse to say that they are powerless, just because there is this law that says that recognizes the right to return of non-Muslims to India. People refused to see themselves as non-citizens, and there were these other expressions of citizenship that were made ubiquitous across the country. and which were rendered, which were folded in and folded up as soon as the pandemic set in. So I would not go to the extent of saying that there's a dehumanization that took place. There's a way in which people were saying that we are not absolutely powerless. No, our powerlessness is not something that can be dictated by a law. No, we are citizens, equal citizens of this country, and that assertion we saw in throughout the first quarter of this year.
The next query is from Dennis Days Thomas. Ma'am, it's heard that a lot of illegal migrants from our neighboring countries. How far can be stopped by CA?
See, the problem with CAA is that it's not stopping illegal. That was the reason why the NRC is being opposed in the Northeast is because the CAA is being opposed in the Northeast is because it makes it possible for illegal migrants to become citizens. And the Northeast doesn't want, Assam does not want an additional burden. It says it already has that additional burden from 1951 to 1971. We have this additional burden of people who did not belong to this territory, to the state, and they can become citizens after 10 years of identification. Now you want people who are illegal migrants to be exempted, non-Muslims of course, to be exempted if they came before 31st December 2014. So we don't want them. So that's the problem that the states in the Northeast have with the CAA. The CAA is about providing citizenship by giving exemption to certain class of people belonging to certain religions from specified countries, exempting them from the category of illegal migrant to enable them to apply for citizenship and become citizens. As illegal migrants, they would have been subject to punishment or subject to deportation if they were identified as illegal migrants. But if they can prove religious persecution, they will be exempted from the category of illegal migrants, and then they can apply and become citizens. So that's the framework with CAA. The NRC is the procedure through which the identification and elimination of of illegal migrants is supposed to happen. Whether or not we have the example of Assam in front of us as to how what kind of procedure, how these bureaucratic procedures actually pan out in reality. And again, the experience of Assam tells us that it's an extremely expensive procedure, and it is a procedure that is not actually a procedure that can weed out illegal migrants, if that's the objective of the procedure. There have been studies of countries like Malaysia, India, and Bangladesh by people who say that identifying illegal migrants through documents is not the most effective way of identifying illegal migrants. So, and then they say through their study, that the history of migration, illegal migration into these countries, and also countries in the north and in the west, tells us that documents are perhaps not difficult to get. And if there is an inversion of relationship, if you think of yourself as a citizen, and you think the kind of cards that you have, identity documents that you have because you are a citizen, you have a voter ID card, you have a passport, none of these documents are citizenship documents, but you have these documents because you are a citizen. Now, if you invert that relationship and then you prove your citizenship through the fact that you have these documents. There's an inversion of the relationship, which means that there's an emphasis on collecting these documents through whatever means to become citizens. So the study by Kamal Sadiq of the three countries, Malaysia, Pakistan, and Bangladesh, tells us that there is a history to how documentary regimes of identification of illegal migrants is not an effective mechanism. And then there is this, again, a normative issue in terms of the kind of imagination that we have of outsiders. No, an illegal migrant is not just an illegal migrant. 1990s onwards, the category of the illegal migrant has been woven into the idea of the security state. So if you were to read the deposition of that was received by the Singhvi Committee report, Singhvi Committee, and the Joint Parliamentary, the Parliamentary Select Committee for the 2003 amendment, a lot of these amendments are about Bangladeshi migrants, illegal migrants, and the measures that these depositions say the act should be addressing. And a lot of these are actually saying that they are a threat to the security of India. And you have legal manifestations, judicial manifestations of these sentiments through the Sarbanan Sonowal case, which in 2005, the judgment in the Sarbanan Sonowal case repealed the Illegal Migrants Determination by Tribunals Act, which applied only to Assam for the identification and deportation of illegal migrants. And one of the things that the judgment said that migration is an act of aggression. So an act of aggression into the territory of India. So the poor people migrating into India for economic reasons could actually be posing a threat to the sovereignty of the country, and they should be seen as an external aggression. And therefore, it was within the purview of the sovereignty of the state and to ensure that to expel these people or take measures to expel these people. And this is something that was taken forward by the judgment in 2014-15 in the Assam Samrita Mahasan case, which laid down the procedures or the requirement for the preparation of the NRC in Assam, to say that, no, it is the responsibility of the state to ensure not just the boundaries, the integrity of the boundaries, but also the security of the people. So one of the things it said when entrusting the Assam-specific provisions to the constitutional bench, it also said that Article 355 of the Constitution needs to be looked at by the Supreme Court, the constitutional bench, to ask whether it's only about the category state means only the boundaries of the state or the people of the state. So, and the Samlita Samiti also goes on to say, the judgment also goes on to say that taking the Sarbanan Sonowal judgment forward, that the state must ensure that illegal migrants are weeded out of the country, not only because they're a threat to the sovereignty of the country, but because they are a threat to the security of the people. And no secularism should not stand in the way of that. And JPC cites that. So the category of the illegal migrant gets woven into the larger discourse of the security state, which is about the exponential power of the executive to take decisions and translate those decisions into legislative measures as well.
But we have quite a few number of long queries. So would it be okay if we take up questions till about 10 more minutes, say till around 5?
Yeah.
We might have to give out the other questions.
Okay.
So next is Ramchandra Bhagarti. Ma'am, how the recent CAA is, this is the one sorry. So I'll just read out a long query, which two queries are clubbed together. It's from Sebastian. Do you make a distinction between social citizenship and political and economic citizenship, as Barbara Harris White does? With my experience of living in North India, I feel that North Indian upper caste Hindu male is considered the most legitimate social citizen of India. The people of the Northeast and the South are looked down upon. Please comment. And his second query, I'll read it alongside. Has there been a shift in the notions of citizenship from secular, inclusive notions to more communal and exclusive notions of citizenship in India, much before the CAA and particularly since late 1980s with the Hindutva mobilization for Ram Janmabhoomi?
Okay. Thank you, Gilbert, for those questions. Okay. Okay. So let me begin with the original premise of the my presentation, where where I said that no, citizenship is about full and equal membership of the political community. Yeah. So immediately when we talk about the fullness and equality of the political community, we are talking about a prior condition of membership. No? So there is something, no, if you are a member of this community, then perhaps you are a full and equal member of the community. So there's a threshold condition, entry. But the fact that you are part of the political community does not necessarily mean that you are an equal member of the political community. So there is this entire framework that says that in order for a person to be seen to be equal citizen, the person should present oneself as a masked citizen, which would basically mean that all your constitutive identities, you need to dissociate yourself from all your constitutive identities in order to be seen as equal, or in order to be an equal citizen. Now, notionally, this could be a basis of liberal citizenship, where a neutral state, a state that does not discriminate among its citizens, would look at its citizens as people without any kind of identifying markers. But in a world that is unequal, and Gilbert has pointed to that world, in an unequal world, it is, and in its socioeconomic context, are entirely different. There are regional disparities. There is a hierarchy of citizens, and it is impossible for people to dissociate themselves from their identities. So there are some identities that become so deeply entrenched that they would mark you, as a citizen. It is and that the power to dissociate yourself from your identity would be unequally available to people. So a poor Dalit woman who works on a construction site would be marked by all these identities and will not be able to readily will not be able to dissociate herself from those identities. And the masked citizen is invariably, as Gilbert Sebastian said, a person who would be marked by the hegemonic categories of being upper caste, North Indian, Brahmin, male. So then that becomes the universal referent from which all other hierarchies of citizenship may perhaps flow. So the hierarchies of citizenship is about the way in which one is located into the in the social context, and the laws would represent those hierarchies and also create those hierarchies. So both the amendments in the Citizenship Act in 1986 and the amendment in 2003 and the amendment in 2019 have created hierarchies and gradations of citizenship. So I would go with what Gilbert said. No, where is the question now? Yeah, to say that yes, there is a gradation of hierarchy that is that citizenship would itself also produce. And yes, there has been a tendency in the citizenship law where it has moved from notions, inclusive notions, to more exclusive notions, and that has to do with the way in which political regimes has the change in political regime. And it's not a coincidence that these dominant notions of citizenship associated with dissent have come at times when the NDA has been in power, and 2003 the Vajpayee government and 2019 the Modi government were the two governments where the dominant ideology of Hindutva was able to make its way into the Citizenship Act. So there is there is a definite tendency, and this tendency is not just confined to India. This tendency is present in all countries, and particularly if you look at the US and the UK, you have very prominent examples of how the buttressing of the walls against migrants has become extremely imperative for regimes that are looking for votes among white supremacists in one case, and the fortification of, in the case of UK, against the security threats presented by the ISIS in a context where there is a perceived failure of multiculturalism in the UK, and there is an increasing clamor for a more robust citizenship regime where citizenship can actually be withdrawn and be considered a privilege in favor of, in preference to what the people think is good for the community. So that is a tendency that is present in most countries of the world, and India is not an exception in that context. But it's pretty much part of the ideology of the ruling regime, and in both cases, it has been the NDA that has brought in the dissent principle into the Citizenship Act.
I think I missed Mr. Bhagatji's question. It was how the recent CAA is related to secularism, as many people are saying that it is anti-secular in nature, violating the constitutional values of seculars.
Yeah. So no, one of the things that the Constituent Assembly had emphatically said that unlike Pakistan, that is identified by religion, the Indian nation was not identified by religion. So that was a negation of religion on which religious identity on which the Indian nation was built. And therefore, the citizenship provisions in the Constitution were looking forward. At that juncture, when the constitutional provisions on citizenship were being framed, there was a conscious kind of dissociation from a past, not just the colonial past, but a past that would bind people with ties that were exclusionary. So therefore, the inclusive frameworks within the citizenship regime at the constituent movement were about saying that no, religion is an identity that is exclusionary. Indian nation is not founded on religion, and therefore citizenship is something that is within the domain of the constitutional ethic. It is about the allegiance and loyalty that people owe to the Constitution, and it's not about some kind of innate DNA and the kind of natural ties that people would have, and founding that ties on religion is something that the Constituent Assembly refused to accept. And therefore, when the CAA introduces religion as a criteria for making a distinction between people to make them eligible for citizenship, it goes against secularism. And which is why one would say that yes, it is against the the basic structure of the Constitution. Even though if you were to look at the principle of basic structure, the principle of basic structure does not, in the original interpretation of the Constitution, it does not. 1973, the Keshwanand Bharti case, it applies to constitutional amendments. It does not apply to law. It does not apply to parliamentary law. It applies only to constitutional amendments. But later on, in other amendments, in other judgments, the Supreme Court has said that even ordinary law will have to or can be brought within the purview of the basic structure doctrine. And secularism is part of our basic structure, as the Bommai judgment laid it down. And so the invocation of religion certainly makes it non-secular. And even if Muslim was included in that category of minority communities, it would still be non-secular because it invokes religion. So that would be the argument that I would give.
Shall I take a final query? Though there are many more, so maybe just one more question for now. Will that be okay?
Yeah, of course. Yeah.
E. Kumar asks, had the makers of the Constitution ever imagined that the deferment would turn to be a Pandora's box in the future?
Yeah, they did. They imagined. Yes, they did. So people who were actually wary of the Parliament being given unfettered powers made a strong point to say that if there is a distinction between constitutional law and an ordinary law, and a constitutional law has. The Constitution is a higher order law, and when within that higher order law you give provision to the Parliament, which is a product of this law, the higher order law, to bring changes that would be of such an extensive nature that would subvert the Constitution itself, that would be something undesirable. And that was a strong argument that was made by P.S. Deshmukh himself, who did not want secularism or secular foundations of citizenship. He did not want the Parliament to have the kind of a legislative sovereignty that the citizenship provisions sought to give it through Article 11. And it's you're true. You're very correct that that has borne out in the present context, where the parliamentary law has sought to kind of erode the foundational principles of constitutional principles of citizenship.
So we will have to cut short the discussion here. I'm sorry to everyone whose queries could not be taken up now. We will, but I'm sure Professor Anupama will be happy to read them. So we will send her queries by email. May I request Professor Michael Tharakan to give the concluding remarks? So your microphone is on mute. Your microphone is on mute, sir.
Hello.
Yes, sir. Now it's audible.
Yeah, I think. Can you hear me? No.
Yes, we can hear you.
Yes, we can.
Okay. I mean, I think something has gone wrong with my connection. So I wish to thank Professor Anupama Roy once more, as well as everybody else for taking part in this discussion so well. I wish to have you here in the KCHR more often. I mean, let me say so. Thank you.
Thank you very much for inviting me, and I'll be happy to look at those questions if you were to send them to me. Thank you so much for all those questions. Thank you.
We will surely send all the queries to you, ma'am, by email. And thank you very much for joining us. In fact, one of the audience pointed out to me in a message that we made you switch off the ceiling fan in the middle of July in Delhi. So, I'm sorry about that. From the number of queries, you see that interest in the subject is so vast. And and thanks a lot for coming. And I want to extend a special thanks to Professor Sanal Mohan also, who first initiated this program as a public talk. I think he's also part of the audience. Thank you, Professor Sanal Mohan. I wish to thank my colleagues at the KCHR, Chairman, Director, Dr. Fashia and Kita for organizing the program. Thank you, all of you, for joining us. And a small announcement, our next public talk is on August 18th by Dr. K.P. Girija, Print Media and Endogenous Medicine, Imprinting Ayurveda in 20th Century Kerala. Thank you very much, ma'am, for joining us.